Now, in this matter of Desmond Moran, an application by Desmond Moran against Ministers Felix and Scott, challenging the local standby to sit in Parliament despite being appointed by the President as technocratic ministers. This matter came up before the Chief Justice, acting at the time, Justice Chang, and the Attorney General took the point in limine that Mr. Moran could not come in that manner to challenge anything connected with an election. That if he's challenging the standing of these two men and their qualifications to sit in Parliament as ministers, they had to go by way of an election petition, which is well-established law. The points in limine were argued, and Mr. Nanalal even went further than points in limine, and I had appealed to the Chief Justice to just limit ourselves to the point in limine that is that the Chief Justice had no jurisdiction to proceed to hear the matter because it was not by way of an election petition. The matter was adjourned, and on the next occasion, the Chief Justice said that he was going to hear the entire matter and then make his ruling. And he was not prepared at that time not to proceed. And so he allowed Mr. Nanalal to again argue no. And after Mr. Nanalal was finished, we took the adjournment and the indication that I would be able to respond by making submissions, oral submissions to him on the next occasion. On the next occasion, the matter was fixed for a date, but he said he would have sent notices. And on the next occasion, when we turned up, we got notice for a day that I would have been in cabinet. But one of the DSG went, the Deputy Solicitor General attended court and said there was no hearing and that the matter, they said they would give another date in the matter. At that point in time, Chief Justice Chang then went on leave, what you call in ordinary terms pre-retirement leave. And that was it in terms of the matter. And even one felt that he would not be able to complete the matter, and probably the matter will have to go de novo. And that's where the matter stood. I think at one point, the Deputy Solicitor General gave me some document which she said was some submission sent in by Mr. Nandalal. And I didn't pay much attention to it because, as I said, I still had to make my response to the overall submissions in the matter. That was that. And today, when I came to work, I was told by a member of our staff that this matter was fixed for decision at 1 o'clock. So I asked, decision by whom? And he said, Chief Justice Chang. I said, but I thought he was on leave. And he said, no. I said, well, that's the notice he's given us, 9 o'clock, 9:30 in the morning. So I even called Ms. Yonet Cummins, who was performing the functions of Chief Justice, to confirm that. And the registrar confirmed that Chief Justice Chang was going to attend at about 1 o'clock to give his decision. I want to say that that was so surprising, and it's improper, really, to treat the Attorney General Chambers in that manner by just suddenly, out of the blues, surfacing to say you're rendering a decision without giving the Attorney General the opportunity to be heard in the first place, because the matter was not completed by the Chief Justice before he went on leave, because I was not allowed an opportunity to respond to the submissions given by Nandalal. And so it's very strange, and I'm very surprised that the learned Chief Justice would purport to proceed to give a decision without hearing from me. It's not the first time. In one of the budget cuts case, you would remember when I was representing the leader of the opposition, and I was at the point when I was to cross-examine Dr. Luncheon. Mr. Chang suddenly said to me that I can't do that because Mr. Granger is not a proper party. We had to appeal that decision, and that matter is before the Court of Appeal right now. That question whether Brigadier Granger was not a proper party in those proceedings. Bearing in mind that in 4 previous cases, the Chief Justice had said he was a proper party. And so, at 1 o'clock, the Deputy Solicitor General attended, and the Chief Justice purported to render his decision. And in rendering his decision, I understand that he has ruled that the 2 ministers, despite being appointed by the President, cannot sit in the Parliament as ministers. And we totally reject that decision. We reject that decision as being erroneous in point of law. And we are going to challenge that decision. The decision, from what I've been able to garner from it, is that the Chief Justice is saying he wouldn't make any coercive order against the Speaker of the National Assembly, but he expects that the Speaker of the National Assembly would follow his ruling, or etc. And you would recall that we had a similar case in the last Parliament where the Speaker at the time, in the light of what had happened, had refused to, in fact, apply any decision that had emanated from the Chief Justice at the time. In this case, we are saying quite clearly that if the learned Chief Justice had given me the opportunity, the learned Chief Justice would have been shown that, one, the decision that Mr. Nandalal relied on, a decision of Chief Justice Kar Singh, as he then was, that that when election results are declared and seats are allocated to any list of candidates, if the list has 90-something members, if the list has 90 or more persons on the list, those persons are all elected members automatically. They all become elected. And if you win, for example, 33 seats, the Chief Justice's decision is saying not only the 33, but the entire list are transformed into elected members. But the Lord Chief Justice did not address his mind to Section 98 of the Representation of the People Act. Section 98 of the Representation of the People Act was made pursuant to the provisions of Article 160, subsection 3, subsection A, Roman 5, which says that Parliament may make provision for the extraction from the lists and the declaration of names of candidates who have been elected. That's what it says. So it meant that this being provided in the Constitution, the Parliament then subsequently made that provision in the Representation of the People's Act, Chapter 103. And in Section 98 of that Act, it says this. It provides inter alia that when seats have been allocated to any list of candidates, the representative or deputy representative of such lists shall extract from the said list as many names belonging to candidates selected by him for the purpose as can be so extracted without their number exceeding the number of seats allocated to that list. So what does that mean? If the representative of the list could only extract names not exceeding, for example, the 33 lists and 33 seats that we have, how could it be said that the other members on the list are elected members? And I will show you why. After those names are extracted, and let's use our list for example, the 33 names, those names now have to be sent to the Chief Election Officer. And the Chief Election Officer shall declare such names in the order of their extraction to be the names of the candidates on such lists who have been elected. So in other words, you cannot have an elected member of any list until one, the names are extracted by the representative of the list, and two, the Chief Election Officer declare those names in the order of their extraction to be names of the names of the candidates on such lists who have been selected. So therefore, it cannot be said that all 90 names on the list are elected members. So it is fallacious to say that, because when having said that, you are now saying that as a result of every member on the list being elected, the president could not properly appoint Mr. Scott and Mr. Felix from being names on that list. But it means that they're saying he has to appoint the technocratic ministers and 2 parliamentary secretaries from persons who would not have been on the list. Because erroneously, they're saying all the persons on the list above 33, even those above 33, are all elected members. And as I showed you now, under the law, you're not an elected member until your name is extracted from the list of candidates. When you have 90 people on the list, it is described as a list of candidates. And you don't move from that status of a candidate to an elected member until your name is extracted, and then the Chief Elections Officer declare you to be elected. And so this decision, I'm surprised that the learned Chief Justice thought it was so important to come out when he's about to retire from the judiciary and decide to make a decision to try to exclude 2 members, sitting members of the government side of the parliament. We are very disturbed by this judgment, and by the manner in which it has been done, and we are going to take whatever recourse we consider necessary in this matter. But I think it's a matter that it's really a dot. It's a matter that is a dot on the administration of justice in this country. And we will deal with this matter in more detail.